Hey everyone, welcome. Sorry about that. Just making sure we don't have any technical difficulties here. So we've got a great show lined up for you tonight. I want to thank everyone who showed up. Great to have you all here, whether you're watching live or you're going to catch us on the replay. We got a full show tonight. I'm going to go through a ton of user or viewer, I guess, submitted questions. This is the most we've ever had, so this is great. If we continue to get so many, I just won't even do legal topics anymore. I'll just cover all of the legal topics will just be all the viewer submitted comments. So please keep that up. Please keep sending them in. It makes my life a lot easier, and we answer them here on the air. So we'll cover those in the Q&A segment at the end. I've also pulled some questions from the forum, the Disability Claim Forum, that I'm going to answer on air as well. Now, before that, I do have two important legal topics that we'll cover that I've got lined up here for tonight. One on the disability side, one on the employment side. Now, these are issues that come up a lot, and I think they'll be important for people to know about. So why don't we start with that? Oh, before that, I will say, okay, perfect. People are already putting their comments in here as well. So what I'd like to do is, before we dive into our legal topics, I do like to just cover the questions as they come in from people, because people may not be able to stick around and stuff like that. So let's start with, before I dive into topics, let's start with some of these questions. First one here is from Jason. Hey, Jason. Says, does provincial disability or LTD care what you buy on your credit card? For example, fun things instead of essentials like video games, drinks, chocolate, clothes, handbags, Amazon online. Interesting. Definitely LTD does not care. Okay, LTD does not care. The only time LTD would care is if you, sometimes when you do an LTD, if your LTD is cut off and you're suing them, you can make a claim for what are called consequential damages and mental distress. So if you say that being cut off from LTD is causing mental distress, you'd have to show that from lack of money, I guess. You'd have to, then they will, if you're making a claim for mental distress, they will examine sometimes your spending habits to see, are you really in financial distress, or are you just spending money on these frivolous things, right? So that is a time when that would matter. But when your claim's approved, they don't care. Now, in terms of provincial disability, I don't know why it's any of provincial disability's business, honestly. I don't think they care. But I guess if you qualify for provincial disability, in theory, your income would be low. So they might care if your money wasn't going towards essentials, I guess. I'm not 100% sure. Definitely with LTD, they would not care. Provincial disability, they wouldn't necessarily care. Oh, buy on a credit card. I see what you're saying. Yeah, I don't think provincial disability is going to care. It's your credit card, right? So it's none of their business really what you're spending on a credit card. Credit cards are not income, so it wouldn't affect your benefits at all. So no, I don't think it would matter, but good question. Another one here from Shuggy. Hey, Shuggy. If you take employer to court for wrongful dismissal and you are on LTD, if you win, will the LTD insurance company take it as employment income and not pay you until the settlement is used up? Yes, possibly. Yeah. For them, that happens a lot because most group insurance policies do allow the employer to what's called offset or deduct or claw back. Sometimes the wording is used. Claw back any benefits that would be paid during a time when you got employment income for the same period. Now, not all policies have that. I recently reviewed a policy for someone, and much to my surprise, it did not have any clawbacks in there, allowing the insurer to claw back for any severance payments or income, employment income, and that kind of thing. So the insurers can do it if they're allowed to do it in their policy. You do have to look at the specific wording. Courts have been very particular to say, like, they'll only allow this when the strict wording is in there. So there were some earlier cases where there were whether severance was the same thing as employment income and all these types of things. So insurers that want to be able to claw back this stuff, they usually cover it pretty broadly. And that's what a court will look at to determine whether to do that, whether that would be possible for them to offset it. But yeah, but yes, what you're describing would normally be the case. And the way they figure it out is like when your LTD is paid, when your employment is paid out, it is paid. The part that they can offset is going to be designated for a period of time, that employment income, and it would be indicated on your ROE, for instance, or also if not on the ROE, you could also have it indicated on something called a T1198. So even though like you might get a lump sum payment of severance, it still will be designated as covering a certain period of time, and the insurer will just match up for that period of time. Say it goes from January to December of 2026, then your payments would stop from January to December of 2026. They would just line up where there's overlap. Okay. Just 1 second here. All right. Sorry. I got a dog that wants to come in my office and I'm alerting someone to let him in because I don't want to get up. Okay. So let's start on the LTD side because this one hits hard for a lot of people. A lot of people on here will be dealing with LTD issues. When someone gets a denial letter from the insurance company, it usually comes with like a short deadline for you to act. That's something we get calls about all the time. Like, you must do this appeal within 90 days, or sometimes this is within 30 days. There can be these deadlines. And because of that pressure, people will often rush right into the appeal. And rushing into the appeal is often where things go wrong. The other thing we see is some people may procrastinate and then rush because they're at the end of the deadline and they're rushing to get the appeal in before the end of the deadline. So what I would suggest, I want to talk through just some 5 steps you can do, 5 things you can think about when you're going to do your appeal, 5 things to do before your appeal. So the first thing to do when you're thinking of doing your own appeal is take a minute to understand the denial letter. And it's important to understand the denial letter for a few reasons. One, you want to look at what the deadline is for you to respond and try to figure out, is this a hard deadline or is this really a soft deadline? Does it even give a deadline? Sometimes it doesn't even give a deadline. Then you want to look at what was the reasons for the denial. I recommend just like taking out a pen or a highlighter. Props here tonight. Take out a pen or a highlighter and go through and just underline or circle anything that looks like a reason they gave for doing the denial. And it does help to mark the reasons, like reason 1, reason 2, reason 3. Now, ideally, let me back up a little bit. If you're going to do this, make a copy of the letter if possible, because you will want to keep this letter to give to lawyers and people later on. And it's not great if you've marked it all up, but let's just pretend that you can get a copy of this somehow, and then it's good to mark it up. Or you could scan it and maybe mark it up online, maybe, if you can do that. But so find the reasons for the denial, and that is very important because it will dictate how you go about doing your appeal. Sometimes the reasons will be things like insufficient medical evidence will often be just stated broadly without giving any specifics. Sometimes they'll say like things like no objective findings, which means there's nothing definitive in the medical records that is measurable, objective and measurable, saying that you have this disability. Sometimes they'll either come right out and say you should be able to do sedentary work, or there's no reason you couldn't do sedentary work. Sedentary work just means work that is not physically demanding. And from the point of view that it doesn't involve a lot of lifting, standing, pushing, pulling, it would be desk work or doing where you can sit for most of the day. That work can still be demanding, but it is a little different than doing physical work. Another couple other reasons for denials. These ones are rougher if you get them. Non-compliance with treatment might be the reason. That's a bad one. If they've alleged that, that is a tough one because that can be a reason, a legitimate reason for them to deny a claim if you've not reasonably complied with your medical treatment. So just keep that in mind. That's a tough one to overcome. Usually you have to go back and just do the treatment that was recommended to fix this one. The last one you could get, and this is the worst one probably, it says you were denied for a pre-existing condition. That's bad usually, because usually they're right about that, and not always. But if you're denied because of a pre-existing condition, it doesn't even get to the point where we're talking about whether you're disabled or not. You just don't have coverage because you're excluded from coverage because of a pre-existing medical condition. Now, keep in mind, pre-existing medical condition does have very specific meaning within these policies. It's not a general that you had this condition in the past. There is a very specific meaning to it, and you should look into that, get legal advice if you need to. The key thing here is like you can't really do an effective appeal unless you know the reasons why they're saying they denied the appeal. Now, we're going to put a pin in that because there's reasons they'll put in a letter, and then there's sometimes the real reasons, the unwritten reasons of the denial, and we'll get to that in a second. Now, the second step that not everyone does, but I certainly do it when I'm representing someone in appeal, the first thing we do is request the full claim file from the insurer. To me, this is a critical step to be doing an effective appeal. Without the claim file, it's really hard to know what's going on and the real reasons. I said in the denial letter, you get the reasons, the official reasons, the reasons they're putting on paper, but the real reasons might be written in the claim file and not written out. Sometimes you have to be able to just have some experience to be able to know what the real reasons are here because they're unwritten, but you can kind of tell from the circumstances and it's maybe some of the comments or things they're saying inside the claim file. Now, a claim file is just the records. It's not a physical file anymore. It's usually now an electronic file, but it will have everything related to your long-term disability claim. Things like the medical records that have been sent in, notes from the case managers. If there's been surveillance on you, that will usually be in there. Copies of forms and call logs and things like this, and any assessments they've had done. So it's quite informative. A lot of their own opinions and things are in there, which can be very helpful. So you definitely will have a much better idea of what's going on with your case, and it can be very eye-opening once you see your claim file. And it can reveal things like you might see by reviewing the claim file, you might see that they've misinterpreted something about your situation. They've gotten they have an honest mistake about some fact that you can clear up. They may have misinterpreted something about the medical records. You might notice that they're missing some documents that you thought they had. And you may be able to spot parts in there where it shows they have bias or tunnel vision, things like that. So without the claim file, you're really flying blind. And that's why I don't do an appeal without the claim file, because I have nothing to really latch on to figure out where their mistakes are, what we can do, like where are the gaps in information, what can we do we can uncover any things we don't know about, like surveillance or any comments they have. We can kind of see where the negativity is in there and figure out, okay, what do we have to do to change their mind? Okay, let's get through this. Number 3. It is helpful when you're doing an appeal to do a doctor's appointment, either to get the doctor, so book a doctor's appointment, either to get the doctor to write a letter, ideally write a letter in support of the appeal. But it's important to have this letter focus on your ability to function and not just reaffirm your diagnosis and this kind of thing and say you can't work. The letter needs to focus on, like, what are your functional limitations with sitting, standing, concentration, these kinds of things, how pain, fatigue affect you, and why that would limit you in the workplace. Doctors sometimes are hesitant to kind of talk about these subjects, but they are qualified to do so in a general sense. And especially if the doctor thinks that it's unrealistic or unsafe for you to return to work, that is something to be very important for them to put in writing. And just keep in mind, like, getting the doctor, so there's no magic words here. So it's better to have a doctor give a description of all of your restrictions and limitations. That's better than just having them write a note that says, patient unable to work. It's better to have a description of limitations than it is to have them just saying can't work, because there's no magic words. Just because your doctor says you can't work, that's irrelevant to the insurance company. They will look at what is the doctor giving for discussions of restrictions and limitations. Okay, number 4, and we got one more after that. So we got 4, then we got 5. Number 4 is it helps in the lead up to your appeal to strengthen your paper trail. Some people will keep a symptom journal to track their symptoms. This can be very helpful to you because your memory will fade over time, and having like a tracking of how your symptoms affected you over time can be very important. Medication and treatment changes, that is something, if you have documents about that, you can show that you are compliant. So sometimes it's helpful to get like medication records from the pharmacy and things like that. So you can show that you've continued to take the medications are increasing, that kind of thing. And I guess other things, what would be other things? If there's any like workplace emails or performance appraisals that show your disability, this would more apply to help strengthen your claim. So if you can get your hands on anything from your employment related to like the accommodations that you receive, the work accommodations means like things they were doing before you went off work to try to help you stay at work, or whether you were taking a lot of sick time and things like that. These kinds of things can help strengthen a claim. And if you can get your hands on them as part of your appeal, it can be very helpful. As the last thing is part of what I would say is part of the strengthening your paper trail would be getting a complete copy of your family doctor's file is the right thing to do in most cases, not all cases, but most cases. It's certainly something, if I'm doing an appeal, I want the family doctor's file going back. You have to strategically figure out how far back you want to go, but the family doctor's file is often the best way to show the whole context and how things have evolved over time, and to show whether you're getting better, you're getting worse, and to give more credibility to your disability. All right, number 5, and this is the last one. When you're considering to appeal, it's realistic to decide whether you should appeal at all, or whether your appeal should be, when I say at all, I mean, do you do this appeal with the insurance company, or do you skip that and go into a legal appeal? The legal appeal is when you sue the insurance company rather than do the internal process of their appeals. Now, generally, I do recommend people do the internal appeal. You should do those until you get to the end of the road and you feel like you've exhausted the reasonable efforts. You have to be mindful of limitation periods and things like that. A limitation period means you only have so long to sue the insurer, and that clock to sue them is usually 2 years, and it starts running from the first denial, not the last denial. So you have to be careful you don't get roped into an appeal process that lasts over 2 years, because you could run out of time to sue them. But you really have to take a stock and think, if you have limited resources and time and energy, putting it all into another appeal directly with the insurance company that has no chance of success is not a good use of your time. You'll just burn through more resources. Your savings will be depleted more. Sometimes it's better to just jump straight to suing the insurance company. That is a decision you have to make on a case-by-case basis to see if it makes sense in your situation. Doesn't always make sense. Sometimes it's the best choice. And I've got some articles I've written online about when to know what makes the most sense. I won't go into full detail here, but generally you want to do an appeal internally when there is an actual chance of success. So for example, situations where there'd be a chance of success is if they're missing a key medical information, or if they have some facts wrong that would be important. Correcting that or getting them the missing medical information sometimes can just lead to an approval, right? But if they've done a full assessment, they have all the information. More importantly, if they feel like you have not complied with treatment or you've done some other thing, those are situations where they're very unlikely to change their mind, and it is going to be a situation where you have to appeal. Certainly, if they have gotten some type of medical report, or they've gotten like a vocational report, if they've paid for some type of medical evidence that helps them and supports their decision to terminate you, then it is almost a 0% chance that they will approve your appeal internally. Those are situations where you have to basically sue them. Think about it. Like, they've already invested the money into disproving your case. They've got something that's favorable to them that gives them a plausible deniability of why they should disapprove your case, because they have this supportive medical evidence that they paid for. Why would they just sort of shrug and say, oh yeah, you're right, we probably will just ignore this evidence that we have? No, they're not going to do that. They're going to rely on that, and you are going to have to appeal it and hopefully get it overturned once you're into suing them. Once you sue them, there is what I call like a change of the dynamic. You're moving from internal appeal people to people who handle litigation appeals. The litigation appeal people have a lot more options that can include approving your claim. And it's quite a different attitude between the two people. They have different incentives, let's say. The internal appeal people are focused on trying to avoid litigation, but also, when possible, denying appeals, approving only cases that are going to be really defensible. Whereas the litigation, once it moves over into litigation and those people take over, it's a whole new set of people. It's not the same people that carry over. Like, once you sue, the whole file gets shifted over to a whole different set of people. These new people, their goal is to get rid of litigation, and that can include settling your case, approving your case, also taking it to trial and getting a decision. So those are the things they can do. But two of the things they can do is either approve you. They can disagree with the internal people and approve it quickly, or they can do settlements with you, which is way a lot of these cases go, or they can eventually approve the case if it turns out that you can convince them that you should be approved. Okay. Oh, wow. We got some questions rolling in here. So let's roll back to some questions. Oh, I still had Shuggy up there. Sorry, Shuggy. Shuggy's back with another one here. So Shuggy's saying, in a position where CPP disability gave insurance company a lump sum, now it looks like I'm on the hook for the taxes on this payment. Is that okay? Oh boy, this tax thing comes up a lot. I cover it in this book. This is my beginner's guide to CPP disability. In a nutshell, there is a way that you do not have to pay these taxes. Okay. You don't have to pay taxes on money that has been repaid to another, on income that has to be repaid somewhere. So no, it is not true. Although, again, I'm going to say up front, I'm not a tax expert. You should get tax advice. Generally speaking, with these types of repayment situations, you're not paying tax, or you shouldn't be paying tax on the amount that's being repaid to the insurer. I go through it in my book at page, where is it in here? There's literally a thing that says taxes. Let me find it. Okay, so it's in the section, part 6, after approval, and it says right there. Oh, let me see if I can see that. Can you see that? It's too blurry. I'll read it to you. It says, being taxed on money you didn't get. Shuggy, that sounds exactly like what you're talking about here. What it says is, the second problem is when Revenue Canada taxes you on income you didn't get. This can happen when you got disability benefits from other payers in the past, yada, yada, yada. And it says, then you're approved for CPP disability and the money gets sent to those third parties like workers' comp or insurance companies. Service Canada will still issue you a T4A that includes a retroactive payment as part of your income, even though you technically didn't get the money. This is what causes the problems. I then go on to explain the sections in the income tax. When you're filing your taxes, there are sections where you have to claim this income that's been repaid. It might be helpful to talk to someone who knows more about taxes, or just do your own research, ChatGPT it. The wording, there's a specific wording that I can never remember. The specific wording is, okay, yeah. It's called income amount repaid. It's at line 23200, 23,200 of your individual return. Income amount repaid. So that is what, Shuggy, you want to be looking at, this concept of that's an income amount repaid. And so you want to be looking at 23, what did I say? 23,200. Man, my brain is not working today here. I believe it. Yeah. 23,200. Exactly. So you want to be looking at line 23,200 of your taxes, and also Googling, ChatGPTing, talking to tax people about an income amount repaid and how to claim that on your taxes so that you don't have to pay that. Your position would be that the amount that Service Canada sent from your retroactive pay over to the insurance company is an income amount repaid and should not be on your taxes. There's two ways that goes about it. You have to include it yourself on your taxes, or sometimes the insurance company will issue an amended T4A themselves that shows the amount repaid. So there's a couple different ways that does get kind of complicated, but that is the process you have to do. Hopefully that helps you. Okay, this one here. Oh, I'm very much like birds. This one is urban nature with what looks like, what kind of bird is that? It looks like, is that a woodpecker? I can't quite. It looks like a woodpecker. I'm happy. I am applying for disability tax credit. Question 2 on the application asks, tell us about the person intending to claim the disability amount. Okay, this then person says, I am intending to claim the credit myself. Do you still need to fill out this section to do you still need to fill out this section to include my wife? If I leave this blank, would this mean my wife would not be able to use my disability tax credit? Yeah, only one person can use your disability tax credit. So it has to be that you either have to fill this in for yourself or your wife. It has to be one or the other. That's my understanding. Now, I'm not in the weeds every day with disability tax credit claims, so I would stand to be corrected there if someone wants to pipe up and say, no, you can put 2. But I believe you have to designate one or the other as the person to receive the benefit, because you can't both use it, in my understanding. So you'd have to pick you or your wife to be the one to use it. And the only other people you can pick to use it, they have to be in your household, and you have to have a financial dependence on them. So that is the other factor. You have to be dependent on them for the necessities of life. So you'd have to make sure that if you were going to pick your wife, that she would qualify because she's your wife and she lives with you. But you'd have to make sure that you qualify that you're dependent on her for the necessities of life. So that, just to make sure. I don't know what your income is and things like that. So maybe you aren't dependent on her for the necessity of life, and in which case you would have to claim it yourself, I believe. But again, not a tax expert, but that is just some food for thought there. All right. Shuggy's got another one. Shuggy's on fire here with questions. I like it. Says here, also on monthly CPP payments, insurance company clawback on the gross amount, not the after-tax amount. Oh boy, yeah. Don't even get me going on this. Do I cover that in the book? Can't remember. Did I cover that in the book? No, this is my other book. This is the guide for long-term disability. I don't think it's in there either. So I've fought this. I actually took a case pro bono for someone who actually maybe saw me. Yeah, it was someone who attended these webinars. So she was in that exact situation where, just to explain it for people watching, like there can be a situation where the insurance company is deducting the gross of, let's say your CPP disability is $1,200 a month. But after taxes, you're only receiving $900 a month, or say $1,000, just to keep it easy. So you're getting paid. You're actually hitting your bank account is $1,000, and $200 is going off to Revenue Canada. But the insurance company is deducting the full $1,200, even though you're not getting it all. So that can seem unfair. Like, the insurance company's deducting $1,200, but you're only getting $1,000. So you're losing out on $200 that you were getting before. Okay. That is, I think, if I'm not mistaken, Shuggy, that is the situation you're talking about. So I fought this unsuccessfully. on behalf of someone. And it will boil down to the wording in the insurance policy. The person I fought it for, I thought we had a chance to get to win, but we did not. So we took it to court, and the court decided against us. And the person decided not to keep appealing it. It will ultimately boil down to the wording of your policy, your long-term disability policy, and what it says about how it describes the taxable, non-taxable offsetting of the payment. The issue you have, here's the issue that can come up. Often the wording is worded such that it's the amount you're entitled to, so it's not the amount you receive. And that, in the case that we did, the court interpreted that the way the policy was worded, it was the amount that was like paid out before taxes is how they interpreted it. That's how it's often interpreted. But it could be interpreted differently if your policy is worded differently. One of the issues you have in most cases is that if let me put myself in the insurance company's point of view, they say why we do it that way is because just because $200 is being deducted off, you might get that money back when you file your taxes at the end of the year. So really, you're not out any money. That's what they're going to say. They will also say that if we start doing like the net payment, people can start gaming the system by just calling up Revenue Canada and saying, yeah, I want you to take off $500 a check. I want you from my CPP disability. So instead of getting $1,500 a month, I just want to get $1,000. $500 is going to go to taxes. Now the insurance can only deduct $1,000, and I get the $500 back for each payment when I file my taxes. So it's the insurance companies see that it's a way that people can scam the system, either intentionally or unintentionally. A lot of people will get, especially if you have the disability tax credit, you'll get back all the taxes that they're taking out. Now, in the case that I did, because the person I was representing, it was about her husband. He was a high income earner, and so there was no chance of him getting the money back. The CPP disability was coming in on top of a bunch of other pensions and things like that. So that was money that was not going to be recouped. So this was a situation where it was impossible for him to like game the system by saying they're deducting the full amount, but I do get the full amount back later. He wasn't going to be able to do that. We still lost that case because of the wording, the way the policy was worded, and the way that the judge interpreted it. But that is what it will boil down in your situation is just ask yourself, like, am I getting that money back at the end of the year anyway? If you're not getting it back anyways, maybe look at, could I get it back? Like, have I applied for the disability tax credit? Is there any other things I can claim on my taxes to lower my taxable income so that I might get that $200 back? If you've exhausted all efforts and you're maximizing all your tax things and you're still not getting the full amount back from what's being deducted off your CPP, then you could look at your policy just to make sure whether it's something you could challenge. But I'll be honest with you, it's a very, very difficult thing to challenge, and it will be hard to find lawyers to challenge it. I probably wouldn't do it again. I did it that time for free just because I wanted to take a run at it and see, could we win one of these? And we're not able to. So I probably would not do it again. Certainly I wouldn't do it again like pro bono. And it would be expensive to have a lawyer fight that kind of case. I'll just let you know. But you could have a lawyer look at it to see, is there a better chance? Like, is there a chance that you could overturn this based on the wording of the policy? Woo. Okay. Shuggy's saying, yes, I got it right. All right. Okay. Thanks for all those questions, folks. I need a little drink of water here. Okay. Let's go to topic number 2. Then once we get through topic number 2, I'll start hitting all the questions that people sent in. All right. Employment law topic. This topic comes up multiple times. Many calls about this. This is people who are I'm going to talk about people who are on fixed term contracts. So when you're hired, there's 2 ways you can be hired. You can be hired indefinitely. So you just are hired, and you're indefinitely until you're fired, I guess. Other times you can be on a fixed term contract. So you're hired with a definite end date. So like when you're hired, your employment contract will say starting date this, ending date this. An indefinite contract of employment just doesn't have an end date on it. It says a start date, it has no end date. When you're on so what we want to talk about is what happens when you're fired early on a fixed term contract. So you may not be dealing with this yourself, but maybe you'll hear someone talking about this sometime and you'll know the answer. So a fixed term contract, there is a definite endpoint. Okay. And unlike now, the other difference here is with a normal employment contract that does not have an end date, people are entitled to severance and a notice period. But with fixed term contracts, those rules do not apply. You're not entitled to notice, common law notice, or severance for a fixed term contract. That's very important. However, the contract itself can set out the terms of like whether you have to give notice and those types of things. Okay. It can be in the contract itself. But absent that, the courts will, like, first thing a court will do if you're fired or ended not on a fixed term contract, the first thing the court will do is look at the contract itself to say, what does it say happens when someone is fired? And if it doesn't say anything, then generally the court will order them to pay out the remainder of the contract to the person being fired, which is good in a lot of cases. So if you're fired and there's 9 months left on your contract, generally, if there's no terms in there that says what happens on firing, they have to pay out the 9 months. So that's something to keep in mind. People don't understand that. It's the general rule that the balance of the contract is owed if you get fired early on a fixed term contract. So that's good. Now, some of these contracts will have terms and clauses within them that can override this general rule. And that is something you're going to want to keep an eye on. Now, even if there are clauses and terms within the contract that say what happens upon being terminated, sometimes they can be still found to be invalid clauses or illegal if the wording is vague or inconsistent, so it's not clear exactly what would happen. If they try to limit your rights in some illegal way, that also can be a grounds to have this thing thrown out. Sometimes what I find, fortunately for my clients, unfortunately for the employers, they will often use like templates they get online from the United States. And the United States has very different laws around employment, very much harder on employees. So they will often include some of that kind of language from the United States that just is illegal in Canada. I've been dealing with that recently in a case. So just keep that in mind. All right. Okay, enough about that. Enough about fixed term contracts. That's just a little snippet for you. This one here says, I am an LTD claimant and have a human rights mediation with my employer. Interesting. I have a human rights mediation next week for a client. Does the possible monetary settlement be deducted by my insurer? If the policy says, can they deduct settlement money from a third party? Yes. If it's possible that some or all of the human rights settlement could be deducted by your LTD. It will all depend on the wording of your insurance policy. And the wording of your insurance policy and the nature of the settlement money you get from the mediation. So generally speaking, at a human rights mediation, once you get a settlement, as part of the settlement, you don't have to, but you should, as part of the settlement, state what the money represents. So there's two major things that money can represent at a settlement of a human rights case. One, it can be money for injury to dignity and self-respect. That's what we would call, like, sometimes you hear it as it's kind of like it's not really a mental distress damage, but it's something that's non-monetary. So it's like a personal injury type damages where you are for pain and suffering. That's the word I'm looking for. It's similar to pain and suffering. It's called injury to dignity and self-respect. That kind of money is usually not deductible. Even if your insurance policy can deduct certain types of money, that type of money is generally not deductible. Sometimes it is, but usually it will not be. It's certainly not taxable. So any money that's paid in a human rights settlement that is designated as injury to dignity and self-respect money, as long as it's reasonable, the amount, Revenue Canada will agree that it's not taxable as income. That's one. The second type of money that can be paid at a human rights mediation is for loss of income. Loss of income is taxable as income. It qualifies to have to pay back EI if you've got EI sickness or EI benefits. And also, it is the most likely type of money that an insurance policy would be allowed to offset. So it's usually in your interest when you're doing one of these mediations to structure it as much as possible to be money for injury to dignity and self-respect. But again, it has to be reasonable. You can't just say if you're settling for $500,000 and say it's all for injury dignity. Like that probably wouldn't fly. Revenue Canada wouldn't agree. There are reasonable ranges depending on your circumstances for what could be awarded for that type of situation. And you have to generally fall within those. Although you could push the limits a little bit, you'd have to fall within those. But that's something you want to be thinking about whenever anyone's doing a mediation with the Human Rights Tribunal. You really need to get it in writing what the money is for. It has to be in writing and signed by both sides. We would call something like this called a minutes of settlement. The minutes of settlement would say it documents what each side agreed to, and you would want the nature of the money to be dictated in there. Okay? All right. Let's go have a look at some of the questions. You know what I forgot? I forgot to put some mood music on here. It doesn't annoy people too much. We'll just put some background music on. There. Let me know if that's too loud. It'll just buzz in the background. Let's go look at some of our questions and answers. Again, these are questions people submitted, and a few of them I took from the online forum. If you're one of the people that submitted the questions, just as I'm going through these, just jump in with any follow-ups that you want to ask or anything like that. Okay, this one says, LTD cut off because the doctor is slow with forms or not documenting. Oops. Sorry, folks. This thing has a timer. Oh, man. How do I turn that off? Okay. These all have a timer on them. I'm going to take the timer off. So this one says, LTD cut off because the doctor is slow with forms or not documenting symptoms properly. What can a person do? Honestly, that is like, we talk about this in the office all the time. Like, we really hate getting those phone calls from people because there's not a lot you can do. There's not a lot of law firm can help you in that situation. Unfortunately, you're in a bad situation if your doctor is slow, not filling out forms properly, because the only thing worse than a doctor doing that is having no doctor at all, because at least a slow doctor who's not great is something. Without having any doctor, it can be worse. So if you're in that situation, the only thing you can really do is make appointments with the doctor for the purposes of doing the forms. That way, they can charge you for it sometimes the doctors just don't prioritize it. So if you make an appointment only for the purpose of the form, don't go in there with any other thing, just for the purpose of the form, meet with them, go over the form, and they can bill it all as part of just the session of seeing you in the 10 minutes or whatever it is they use, or 5 minutes. That is the right way to do it. That can get around the problem where doctors are well-meaning but overloaded and just can't get to all the paperwork, because they may have hundreds of these that they have to get to, and it's just impossible for them to do it with the way their practice is set up. What else can you do? Well, you can change doctors. That's not great. There are organizations, in fact, I met one. I went to a legal conference 2 weeks ago. So there are companies like, let me look it up here. I'll share my screen here. This was a company that I met at the conference. Tranquil Bay. They do okay. I'll share my screen and show you what they are all about. Now, I'm not endorsing this company. I don't know anything about this company other than that they gave me, I have their business card right here, and I'm thinking of using them at some point with some of my clients, but I'll just show you what they look like, just so you know. So let's go, share screen. So I'm not endorsing this company, but I am going to show you about it. There. Are you guys seeing that? Just let me know if you're seeing that or not. Oh, music's too loud. Yeah, all right. There. Should we do it? You guys, oh, you're not seeing it. There, now you're seeing it. So this is their website, Circle Bay Medical. This is the first time I've been to their website. Services. So what they are is they will do, if you need forms filled out, this is what they will do. So they will fill out disability forms, they'll do injury assessments, etc. Yeah. Actually, I know this guy. You know Bob Lebrecht. I didn't even know he was part of this company. I probably didn't know that. I just didn't put it all together. Now, I don't know if you can self-refer yourself there or if you have to go through a lawyer. That is what I don't know. Or if your doctor has to refer you. But basically, they're just a service that will fill out forms for people. And it's done virtually. Specialist referrals, virtual appointments, detailed reporting. Yeah. So just keep that in mind. So that's another option. You go to something like Circle Bay or an equivalent to get them to do the forms that you need. Now that you'd want to clear that through your doctor because you don't want to get into a situation where you're causing more tension with your doctor because they feel like you're going around their back and things. So this is something you'd want to clear with your doctor, and you could potentially do that. All right. Okay. Now, I think we have another question here. Here's another question. This one says, I know you don't have to disclose your medical history if you're on LTD and decide to return to the workforce. What happens if you decide to return to work and you get sick months or a year in? Okay, good question, Ricky. So you don't have to disclose your specific medical particulars, but if you are going to need accommodations in the workplace, you do have to disclose that you need accommodations because of a disability. Okay, you don't have to go into all the details, but you have to give enough information so the employer knows that it's safe for you to work and what they would need to do to be able to help you. If you go back to work and you get sick a few months in, under every long-term disability policy, there is something called a reoccurrence clause. I shouldn't say under every, but most of them have a reoccurrence clause. So what that means is when you go back to work from a disability leave on long-term disability, if your disability reoccurs within a certain amount of months, usually 6 months, but it can be longer, it can be shorter, that you are automatically able to go back onto the same claim you already had, so you don't have to start over. But if you go back to work and then your disability comes back and you're outside of the reoccurrence period, then you have to start over with an entirely new claim and go through the short-term disability, get into the long-term, and that kind of thing. So that's often something that you have to keep an eye out for. Is are you before the insurance? Are you before the reoccurrence period or after? That's what would happen. Okay, Shuggy is back again with a question. Can insurance company be sued if they gave your employer wrong information and your employer let you go by using frustration of contract? Probably not. This is probably not a practical thing to sue an insurance company over. You would also have to prove that they weren't, when you say wrong information, like that wouldn't be something you could sue the insurance over. If they passed on information, you feel the information is wrong, that's not a reason to sue the insurance company. People can disagree over whether information is right or wrong. If it was intentionally wrong, like that's different, but probably not what we're talking about here. But no, just passing on information. It would have to be information, like you wouldn't be able to sue them, but you could probably file a privacy complaint if they gave information they weren't authorized to give. That's a little different. Again, I often discourage people from going down that road, not usually productive. But no, you're probably not going to be able to sue an insurance company for that. Plus, whether frustration of contract happens or not is a matter of fact. So it really has nothing to do with the insurance company. A court would look at it and say, like, based on all the medical evidence, was your employment frustrated at a certain point in time or not? Like, when did a frustration occur, if at all? It is independent of anything the insurance company does. It's dependent on a reasonable assessment of your capacity to work and fulfill duties in your employment agreement. So the whole way around, I don't think there would be any grounds generally in this kind of situation to sue an employer or sue the insurance company. Okay, this one said, if long-term disability harasses me about update each 3 months as beyond 36 months and call me each 3 months for a medical update. Yeah, it is definitely frustrating. It wouldn't technically be considered harassment to follow up every 3 months or so for information. It all depends on the context. So when a court is looking at whether something is reasonable or not, they will look at the context and look at, well, why is the insurance company following up at this frequency? Is it because you're something to do with the kind of treatment you're getting, something to do with the condition, medical condition you have, that's where you're going through treatment and there's changes and these kinds of things. So that's what would be looked at, full context. It's not normal for an insurance company to follow up every 3 months forever, but there can be stretches of time where that is reasonable for them to do that because of the nature of your claim. And like you're saying, you're at 36 months. That means you're probably at or near or just beyond a change of definition. That's still reasonable for them to be following up a lot, especially if they're still trying to assess. Usually when you're seeing a lot of follow-up like that, the insurance company is still assessing whether you meet the definition for any occupation versus own occupation. I would expect that that's what's going on, is that the insurance company is still trying to assess whether they can prove that you do not meet the definition of disability for any occupation. They're following up closely. They will also follow up closely if they feel like you might not be following medical advice or these types of things. So that's probably what's going on there, but it probably would not be considered legal harassment. Okay. Sorry, these all have timers on now for some reason. Okay. This one says, what if someone fears that family doctor's communication or support might harm their LTD claim? Oh boy. I think this is the same person who's asking the first question. So I guess if you're worried that your doctor might intentionally or unintentionally, probably unintentionally harm their claim just by being incompetent or not taking it serious or these types of things, you want to have like a conversation, a candid conversation with the doctor about what the insurance company needs. And you would want to, whenever you meet with the doctor, talk about what your functional limitations are, your day-to-day limitations, so that that gets recorded into the records. The other thing you could be is try to be referred to another like therapist, psychologist, another doctor, someone who might be able to come in and help and give a report, that kind of thing. So you can talk to your doctor about a referral somewhere. And again, like the last thing you wanted, like the last thing you should do, the last resort is switch doctors. But again, most places in Canada, switching a doctor means you go from having a bad doctor to no doctor, and no doctor can be worse than a bad doctor. Okay, so just keep that in mind. You may have the option maybe to go to, like I said, something like this clinic, Circle Bay Clinic, places like that do forums and things like that. That would be another thing you could do. What can someone do if their employer runs the insurance plan and they feel they treated unfairly? Oh, what can they do if their employer also runs the insurance plan and they feel like they've been treated unfairly? So sometimes there can be conflicts of interest, potentially when an employer runs the insurance plan. That is rare to have that happen. So I pretty much know where you're probably working things, because those are rare types of plans in Canada. Normally when that happens, the insurance plan is still run at arm's length from the employer. So the employer doesn't have direct say into the insurance plan. There are people administering it that have independent duties and things like that. One way to just protect yourself is just get copies of your claim file so you can see everything that's going on, and consider getting like independent advice early on if you think that there's something fishy happening. If you think there's pressure or these things, like any inconsistent treatment that you're getting from them, just document it, keep records. And again, like it is very possible for an insurer, the employer, to run in the insurance plan and not be biased. So, but if there is bias, then courts do treat that quite seriously. This one says, what are an employee's rights if they can't return to work medically after a leave? Well, if you can't return to work after a medical leave, then I guess what you say, what are their rights? So one you would be to go on long-term disability insurance benefits. As far as your employer goes, employers have an obligation through the Human Rights Act to accommodate employees with disabilities. And one of the reasonable accommodations would be allowing people to be on an unpaid sick leave. So if you're on a leave and you can't return to work, I guess what's bothering me here in this question is what to do after the leave, I think is what it said. Let me read this again. What are the employee's rights if they can't return to work after a leave? Well, stay on leave is what I would say. I guess maybe what you're saying is the insurer is saying you should go back, but generally you would just stay on the leave. You'd have to get medical records from your doctor, a medical note from your doctor confirming that you're not fit to go back to work, and just extend the medical leave. I hope that answers your question, but put in a follow-up if there's anything. Let's keep going here. This one says, after 25 years in Ontario, is severance owed, and can a worker ask HR about it? So this is a good question. yes, someone who's worked 25 years somewhere is entitled to some type of severance. A lot will depend on your employment situation and whether you're in a union or non-union. You can ask HR about it, but like, you're only entitled to severance if the employer is letting you go. You're not just entitled, like if you want to resign, you're not entitled to any severance money if you resign. You're only entitled to severance if the employer lets you go. So sometimes people think like, can I resign and get severance? No, you can't resign and get severance unless you're forced to resign because of a toxic work environment. They're changing your job in like a very significant way. There's no right to severance unless you're being let go, like fired, that kind of thing. But yes, someone who's worked 25 years could be entitled to a lot of severance, actually, if they're being let go or forced out. There are two types of severance you can get. There's the minimum severance that's owed under the provincial, whatever province you're in. You said Ontario. So in Ontario, there's the Employment Standards Act, which for a 25-year employee would give 8 weeks of severance and then some amount of weeks of 8 weeks of termination pay and then another 25 weeks of severance pay. So you could be getting a lot there. What's that up to, like 33? Yeah, 33 weeks of pay. So that would be the minimum that you could get in most situations. I'm not giving you this person advice directly because I don't know your whole situation, but there are minimum amounts that you probably would be owed, but a lot will depend on whether you're in a union and anything that's in your employment contract. You could be owed a lot more than 33 weeks as well. Okay. This one here says, new case manager, unfamiliar with history, asking basic questions, shortening approval despite CPP approval. How to approach this without being confrontational. Okay, so with new case managers, it can be very annoying when you're on long-term disability. There's sometimes a high turnover in these positions. New people come in with different priorities, good and bad. And things can change for any reason sometimes. Sometimes a case that was more in a maintenance mode where they're not checking in that often, they can move it to be more check-ins. So I guess what you would want to do, you'd want to try to approach the case manager just to see what information they need. The fact that they don't know the history and things, you just have to be patient with them and try to bring them up to speed. New case managers coming in, they're often dealing with many cases. They got a high caseload. So for you, it's like your only case. For them, they're trying to keep up on everything. So they just may not have the time to fully go through everything in your record and know every detail. And so I would just encourage you to be patient with them, even though it's annoying that you have to repeat all this stuff and things like that. I definitely wouldn't be confrontational about it. And I wouldn't try to admonish them about it. Think of it from their point of view. They just may be an overwhelmed person. And so patience is usually the best virtue in this kind of situation. Okay, this one says, what happens legally when an insurer changes its interpretation of entitlement after paying LTD for years? What options do claimants have? It can be hard for insurers to just up and change their view on a file, especially if you're into the ending occupation period. There is an assumption that if there has to be some change in status for them to come in and start mucking around and completely upend the claim. But again, it's case by case. A court would look at what grounds do they have to think that there's been some change in status. They're allowed to, the change in status might be they get updates of your medical file and see you're no longer have a certain diagnosis, you're no longer on a certain medication, you've improved, these kinds of things. Those are reasons why they can change their interpretation. Once you're approved for CPP or for long-term disability, it's not an all or nothing thing. It's always subject to ongoing proof of disability. And if circumstances change over the years, they can come back and revisit it and find that you're no longer disabled. Okay, it's not written in stone at all. They're allowed to change over time, and that is something you have to keep an eye out for. Things that can trigger them to change after years of just paying the claim would be seeing, like, they may randomly just audit people's social media, and if they see things on there that look like you're leading a lifestyle and doing things that is not consistent with the kind of disability that you've described to them, that will be a red flag and cause them to do more investigation. That could also trigger them to have the ability to do surveillance on you. They could also, what they can do too, another trigger might be that they get an update from your family doctor's records, and that they look it over and it doesn't match with what they do on surveillance or things like that. They can get you to fill out a form asking about, they may know, like for example, they may have figured out somehow that you are volunteering somewhere, and they'll send you a questionnaire, and on the questionnaire it says, are you volunteering anywhere? And you say no, then that would be a big problem. That would trigger there to be a change in interpretation and these kinds of things, because they feel like you're lying about that. You may be lying about other things. So these are all the things that you have to be careful of when you're on a long-term claim. And these are the things they do to try to catch people and have grounds to stop the payments. Okay, here's an interesting one. If someone didn't submit a critical illness claim at diagnosis, is there a time limit to file? Yes. There are very strict time limits on critical illness type claims. Now, the deadlines are in the policy itself, and they're usually 30 to 90 days. But again, you have to look at your own policy and see what the deadline is to file the notice of claim and proof of claim. Now, apart from that, their courts can sometimes give extensions of time. So, like, even though you're late in filing the claim, courts can give extensions of time up to certain, I don't want to quote how far you can go, but they can up to a year or two sometimes, depending on the circumstances. It could be no extension if the court feels like you knew about the claim and you just decided not to do it. So, yeah, there can be the sooner you are, the closer you are to like the whatever the time limit it was, the 90 days or whatever, the closer you are to that, the better. The farther you away from it is the problem. Once you get a few years out, it becomes very hard to do that. But you should always get an individualized assessment on that, on whether you have the ability to go back and file a late claim. The insurance companies almost always deny these late claims, and then you have to sue them because, again, in order for your claim to succeed, a judge would have to decide that in the circumstances the courts have some discretion to allow late claims, even though legally it is late. But because it's legally late, most insurers are going to just deny it to see if you sue them. And then if you sue them, then they'll decide, should we fight this or not? What's the chances a judge is going to throw this out? Or a judge is grant an extension? That's very contextual on whether the judge would do that. What happens legally when an insurer changes its interpretation? Oh, I've already done that one. Does the 90-day reconsideration deadline for a CPP denial run from the date printed on the letter or the date I actually received it, especially with mail delays? Okay, so the 90 days runs from the date you received the letter. Now, the problem you have is sometimes you can't prove when you received the letter. And so that is often a point of dispute, because a lot of people will say, I just didn't get it. But if it was at your mailbox and you didn't just go to your mailbox, like, that's different. So if it's lost in the mail is one thing, but if it's sitting in your mailbox and you just didn't look at any of your mail for a month, you're probably going to be in trouble. They will probably default to like the date on the letter plus like 5 days or something like that. But certainly, if you can prove for whatever reason that there was a delay, like, for example, the postal strike and things like that, then I think you have a very good case. Because everybody knows there was the postal strike and mail was delayed. If that was the reason, then you've got good grounds to say that the clock started running from the date you actually received it. But again, it always comes down to case by case. You have to if you can prove when you received the letter, then you would be able to argue that it runs from the date you received the letter onward. Another CPP question, and this one says, how to request your CPP file. Do I need to list every document or category? No, you don't. You just need to say you want your complete CPP disability file, including any medical, internal notes, decision document, etc. That will cover everything in there. That's all you usually have to ask for. You don't need to list every document or category or thing like that. Just say you want the complete CPP disability file, including all medical, internal notes, and decision documents. That should get you everything. This one says, should I also request my old 2013 CPP disability application that was denied under a misdiagnosis? Could it help? I tend to, if I have a client who's had a previous CPP claim, yes, I ask for all copies of all CPP disability applications previously submitted if they still have them on record, because those old applications will have a lot of information that you've given before, and they will come out. Usually, like if you don't request them up front, that will get disclosed later on if your claim is denied and it's going to the Social Security Tribunal. Usually they'll disclose all that in there. So it could be that you've now got conflicting information, stuff you said on one and the other, you didn't do it intentionally, but you're saying things that conflict with one another when you didn't mean to. It just can create problems for you. I will always try to get old applications. If I'm filing a new application for someone who had an old application, I always get the old application first. And I tell the client, look, this is going to delay things, but this is really important because we can't have you filling out things and saying things that contradict what you put in the old application. Now, this one is going back to 2013. If this was for a completely different illness and things, then maybe you would not need to go back that far. That's quite a ways back from now to 2013. But if it's the same illness and overlapping, the more that it overlaps with the current claim in terms of the medical conditions and things like that, then I would definitely want to go get it. This is another one about the CPP. It says, should I ask for an electronic copies, paper copies, in-person pickup when accessing it? This will just come down to your choice. I'm pretty sure when we request these, we get an electronic copy, which is probably the best thing. If you get it sent to you that'll be the fastest. I don't think they keep paper copies of everything. I think everything they have is digital, so they would have to print it all out for you and then ship it. As far as picking it up somewhere, like that is a lot of things that have to happen. They have to print it out, ship it internally to some local office. Then you have to just hope they don't mishandle it or misput it somewhere. So there is a lot of, if you want to pick it up somewhere, there's some problems there. They might just mail it directly to you. There might be a charge for that. There could be a charge for them to mail it directly to you. But generally, you would want to request a digital copy if possible. That would be the easiest thing to do. These were questions someone put on the forum, actually. All right, I'm going to do one or two more, and then we're going to call it a night. This is another one from the forum, but I'm thinking maybe this is someone who was here tonight because it's the same question, but we'll do it anyway. My employer laid me off, and I received a final paycheck. Manulife is offsetting my LTD using the gross amount, not the net, demanding repayment of several months. How is this allowed? So most policies, I mentioned this before, most policies allow them to offset the gross amount, not net. But legally, they can claim the gross amount of like severance, this type of money, and it can create kind of imbalances with your LTD. So unfortunately, it will depend on the wording of your policy. If the policy allows them to deduct gross payments, the gross amount, then that is what they're allowed to do, unfortunately. So you have to look at your policy and try to figure it out. But Generally, they're right on this. I don't know in your situation if they're right or wrong, but generally they get this right because they're very good with knowing the money part of it, but you have to review it. Okay. I think that's all I have for tonight, unless anyone has anything else. But we've had a pretty good show, lots of questions, and I'll be back next week, same place, same time. Please do continue to send in your questions. You can send them to, I'll put it in here, send your questions to support@resolutelegal.ca. If you send the questions there, our support team, led by Jen, who is our support team manager, intake manager, she will see your questions and she puts them aside for me to be able to answer here on the show. All right, take care, everyone. I wish you all well. We'll see you back here next week.